I see Mr. Lindstrom and Mr. King are connected. We will call the next case, which is 2 Crooked Creek versus the Cass County Treasurer. Each side has 15 minutes. Mr. Lindstrom, I assume you will try to reserve some of that 15 minutes for rebuttal, and we will start with you, Mr. Lindstrom.
All right, I had a technical moment there. Apologize, can you see me? My screen went to the wrong place.
Oh, no, we got you. You're good. We can see you and hear you.
Thank you, Your Honor. Yes, I'm arguing on behalf, Aaron Lindstrom, on behalf of the appellants here. I'd like to resolve 3 minutes for rebuttal if possible. Madam Chief Justice, and may it please the court, the question in this case is what did the legislature intend for Section 78L to do? And the answer provided by the Court of Appeals opinion and by the Cass County Treasurer's position is that it won't do anything. They're going to turn the entire Section 78L into surplusage. And that's contrary to the structure and text of the act and how this court has previously interpreted the statute in perfecting church. So as to the structure, the legislature went to great lengths in Section 78, 78A, all the way through 78K to provide a mechanism that would give constructive notice, at least constructive notice, to property owners before foreclosing on their homes. And then the judgment of foreclosure can happen only if those things have happened, because if there hasn't been at least constructive notice, then it violates the due process clause. So 78L comes into play only after those events had happened, which means that it makes sense only if it is requiring actual notice. And that's consistent with the plain text of the statute, which says that it allows a claim for someone who did not receive any notice, and you don't receive constructive notice. Constructive notice exists in the law as a legal fiction when you didn't receive notice. So when you didn't receive actual notice. And this is consistent with how this court interpreted this very section when it read it in perfecting church. And in perfecting church, this court equated the phrase receive any notice with receiving actual notice. So for all those reasons, we think the Court of Appeals interpretation is wrong and should be reversed. And I'd be happy to entertain any questions.
Thank you, Mr. Lindstrom. I'll start this one with Justice Viviano.
I have no questions at this time.
Justice Bernstein.
No questions at this time, but I'd like to reserve.
Justice Clement.
No questions. Thank you.
Justice Kavanaugh.
None for me.
Justice Markman.
I'd like to welcome back Mr. Lindstrom. I have no questions, however.
Thank you, Your Honor.
Justice Zara.
I guess I'll bite. Mr. Lindstrom, you're suggesting that Section 78L creates a cause of action when there is no actual notice. But why can't it simply be that this is creating 2 remedies for someone who has been denied their property after judgment of foreclosure enters? For example, the redemption period expires, they can either bring an action in the circuit court to set aside the judgment of foreclosure according to perfecting church and get the property back, or they can bring a claim for monetary damages under Section 78L. But in either instance, property owners must first establish that the notice was insufficient to satisfy due process. Why is that not consistent with the language of the statute?
I think it's not consistent with the phrase receive any notice, which, as I noted, is used to denote actual notice, not constructive notice. And it also would mean that the legislature intentionally designed a statutory remedy that is a worse remedy than would be available. There's never an instance where you would choose that. You'd always choose to go the due process route so that you could get the remedy that would actually get you your property back. You're always better off if you have the option of getting the property back. So I just don't think anyone would ever take that option.
Okay, thank you.
Any additional questions for Mr. Lindstrom from any of the justices?
Can I please ask a question?
Yes, absolutely. Justice Markman.
Mr. Lindstrom, we had a case before this court several years ago having to do with mold builders liens, and a critical part of the statute that was in dispute in that case states the mold builders lien attaches when actual or constructive notice is received. What do you make of the use of the term received in that context?
In that case, they've said actual or constructive notice is received. So they're putting the two ideas together. I would say that it fits well with one and not well with the other one. And so that may just been, well, they didn't take the effort to say received actual notice or been provided constructive notice. Again, actual notice is personally receiving something as it's defined in Black's Law Dictionary, as we quoted in our brief, whereas receiving something, whereas constructive notice is not received. That's why the Court of Claims in this case put the phrase received in scare quotes, which I think shows it's deviating from the plain language. So I think it might be used sometimes inaccurately by saying that the example you quoted, but the better phrasing of it is that you receive actual notice, you don't receive constructive notice. And I think, again, with the whole structure of the act in mind, that further reinforces this kind of textual specific point.
Thank you. Thank you, Counsel.
Mr. Lindstrom, you can reserve a bunch of time, see what happens next.
I'd be happy to reserve the remainder of my time. Thank you.
Thank you. Mr. King.
Thank you. I should be unmuted now. Can you hear me?
We can.
Thank you. May it please the court, Chief Justice and the remaining justices of the court. My name's Thomas King. I'm here on behalf of the FLE, Cass County Treasurer. I just want to make one preliminary statement in light of the fact that this court recently decided another case by the name of Raffaelli that all of us are very familiar with, particularly treasurers and this court. The court will be happy to know that the legislature has taken up this court's decision, and there are acts pending now in the legislature to conform the statute to the ruling by this court. Senate bills 676 and 1137 and House Bill 6288. Senate bill's been reported out of committee and with a recommendation to approve. I know we're not here on that issue, but I thought since it was also a tax foreclosure case, I would provide that information to the court. I'm glad that Mr. Lindstrom kept his remarks to statutory construction, because this case is about statutory construction and the Court of Appeals and quite frankly, the Court of Claims application of the facts to the statute. The Court of Claims made several findings that were very important in the application of those facts to the statute. One, it found that Mr. Antipoff, who is the Court of Claims said his testimony was basically the issue of notice depended largely on belief of his testimony, and found him after repeated cross-examination about truthfulness not to be believable with regard to his testimony. In addition, the court specifically referred to the exhibits that were entered showing that the notices had been properly sent by the treasurer, all of the notices, that in addition there were regular mail notices that did not come back, were in fact delivered in addition to the posting information, including a picture of the posting on the front door of the property, as well as the publication. Armed with those findings, the Court of Claims found that the appellant received at least some of the notices, mailed notices. That's at Court of Claims opinion at 15. And I suspect it's referring back to its findings regarding the mail notices not being returned. And also that the appellant received the posted notice because being in exercising dominion and control over the property, they were deemed to have received that notice. So those were the findings below. The question that's being raised now is whether those findings are sufficient based upon the kind of tortured application of the statute that's being proposed by appellants. First, appellants say that constructive notice is not notice. Remember, the statute says notice, doesn't say constructive notice, doesn't say actual notice in MCL 211-78L. And if you go to Black's, you find out that notice, constructive notice, and actual notice are subsets of notice. And so by use of the term notice, the legislature has included constructive notice in the notice provided for in MCLA 211-78L. That's also consistent with analyzing the statute as a whole. Both parties have cited case law that says that this court has to do it as a unified body. And if the court looks at the statute, this statute, unlike a lot of the statutes that I see, and I'm sure more that this court sees, seems to be well integrated. Certain sections seem to work pretty well with other sections. And let me point out how that happens. MCL 211-78-2 gives the explicit intent of the legislature as to what it's trying to do with the statute. It's trying to provide due process notice and not any cause of action above and beyond due process notice. That's the plain reading of 211-78-2. It's unusual that we have such a statement from the legislature. The court's often required to look at the language and try to divine what the legislature intended. This particular statute, we have a statement from the legislature. This is what our intent was, and this is what we wanted to do. And counsel says, well, that didn't include 211-78L. That's just separate from that. But it's part of the act, and it's part of what the legislature said the intent covered. Let's talk about MCL 211-78L and the language in that. Nowhere in that statute does it use the word actual, and nowhere in that statute does it indicate that the purpose of that provision is to provide an additional remedy. And in fact, if the court reads that provision very closely, what that provision really intended to do was to limit the remedy that was available to persons whose property had been foreclosed against after that property had been sold to third parties. This court.
Mr. King, I'm going to interrupt you just because I want to make sure if my colleagues have questions, they have time to ask them. So let me,
sure.
You've given us a good start. I'm starting again with Justice Viviano.
And I have no questions at this time.
Justice Bernstein.
No questions.
Justice Clement.
No questions.
Justice Kavanaugh.
I have none.
Justice Markman.
Just one question. Counsel, is it your view that constructive notice always satisfies minimal obligations of due process?
Possibly not in every circumstance. However, we already have a ruling that says that minimum due process was in fact established in this case. In the other case that went through this court all the way up to the United States Supreme Court, this court denied leave. That case is now final. The constitutional questions are not part of this case. The case is one of statutory interpretation. And as the Court of Appeals properly found, the issue of whether due process was satisfied is now final and has been determined. So in this case, the ruling is that it has been and that it was sufficient.
So it's beyond our charge to be looking at the specific circumstances that might arguably have some effect upon that distinct conclusion.
It's beyond this court's, the issue before this court, if it is looking at constitutional questions that have already been decided. If it's looking at statutory construction issues, of course it can look at the statutory and whether the statute requires something different than the Constitution requires.
Thank you, counsel.
I'm just gonna, I want to give Justice Zara a chance to ask any questions, Mr. King.
Thank you, Chief. You know, I read Perfecting Church and it wasn't entirely clear how that applies to this case, but it is clear that there appears to be two kinds of challenges available to a property owner whose interests are extinguished by tax foreclosure. One way is that the owner may seek equitable relief in the form of setting aside the foreclosure judgment. And I think Perfecting Church makes it pretty clear in that situations where the owner was not accorded constitutionally adequate notice sufficient to satisfy minimum due process requirements. But it also notes a second remedy that is that the property owner may bring a claim for damages under MCL 21178L. And it suggests, I think, in Perfecting Church, it can be read to suggest that that's where there's no actual notice. Does it not make logical sense that a claim for equitable relief requires a showing of lack of constitutionally adequate notice, while a mere claim for monetary damages would be more relaxed, such that a person who didn't receive actual notice can collect?
The legislature could make that distinction if they wish to, but this is a matter of statutory construction, and the legislature indicated in 21178-2 that they were not making that distinction. And then the question becomes under MCL 21178L, what does any notice required by this statute mean? And so what we get back to the question of what notice is required by the statute. The notice required by the statute, we believe, is limited to due process notice. As the legislature said, that was their intention. And I can point out how it all works together to provide the due process notice, including those sections that counsel in his brief indicates speak to greater than due process notice. For example, counsel indicates that MCL 211A4 provides a separate level of notice to mortgage holders, when in fact he plucks out the last sentence of that subsection. And if you look up above, you see that the first two sentences refer to notice being given to the treasurer of those unrecorded interests being in existence. And the third sentence talks about persons. And if you pluck it out and you don't relate it to the earlier sentences in the same section, then that section means that everybody in the state of Michigan, I guess, is entitled to notice of the foreclosure, not just the people with interest in the property, which is ludicrous, of course. And I don't submit that that was the legislature's intent.
I greatly appreciate you going to the statute and parsing the words of the statute and analyzing the text the way I do most of my work. But my question really related to our court's decision in Perfecting Church. And I think around pages 10, 11 of that opinion, it appears to recognize the availability of a damage remedy under the statute when the property owner does not receive actual notice of the tax foreclosure. And so I guess the question is really about Perfecting Church.
I read Perfecting Church. Oh, I'm sorry. I'm sorry. I didn't mean to interrupt.
No, I'm just asking, is Perfecting Church precedent that we have to follow that would favor Mr. Lindstrom's position?
Okay. I read Perfecting Church a little bit differently than that, although I acknowledge that language is in Perfecting Church, and I'll get to that in just a minute. I read Perfecting Church as saying that the Constitution requires that even after the property is sold to a third party, that persons that did not get due process notice are entitled to recover the property. Perfecting Church was actually a case where the property was sold to a third party, and MCL of course, 78L says that if it's sold to a third party, you're limited to money damages. And Perfecting Church actually holds that's not the case. Now, as the Court of Appeals opined, and as I believe, Perfecting Churches, that phrase that you talk about in Perfecting Church that says there may be that the legislature can create an additional remedy is dicta in that case. And the question is, did the legislature create an additional remedy? And I don't believe that they did. I believe that their stated intention was covered by this. So then 21178 A4, which is what counsel refers to as the additional notice to the mortgage holder, once you equate that with the rest of that subsection and you realize that it's after giving the notice to the treasurer of their existence, then it falls neatly within MCL 21178 I6, which says what parties are entitled to notice, because it's now part of the treasurer's file, because they've sent in the notice, it's part of the treasurer's tax records, and it's part of 21178 I6. So again, we're at what the legislature did to create a unified body of foreclosure. In addition, if you look very closely, the forfeiture provisions of MCL 21178 G, which say forfeiture occurs on March 1st and 45 days thereafter, the treasurer must record a certificate of forfeiture, dovetail very nicely with MCL 21178 I believe it's 1, which indicates that the treasurer by May 1 then is required to initiate a title search. And that works out very neatly, because what happens is the certificate of foreclosure is recorded mid-April. Then when the title search is done on or about initiated May 1, it shows up in the title search. And so you get all of the interests in the property that are of record, and you get the certificate of forfeiture. And then anybody else that wanders in and takes an interest in the property, gives a mortgage, like in this case, they all, one would think, would do a title search and find the.
Can I summarize for you? Are you essentially
Yeah.
telling me that if I take the portion of Perfecting Church that I find a little bit disconcerting and conclude that that's dicta, the rest of the statute flows very nicely together? That's your.
And complies with the intent of the legislature under MCL 21178-2. And that MCL 21178L was really a provision designed to limit the rights of owners when there's a third party sale involved, not to get the property back. And that's what Perfecting Church really did. It undid that and then said you got to go back to circuit court to get that order. And now we've got the two different proceedings that essentially accomplish, I believe the same thing. So I suppose the legislature may address that in the upcoming, because it's really Perfecting Church is the judicial remedy grafted on a statute that the legislature didn't put in it. You can't subscribe that to the intent of the legislature. So if we're talking about the intent of the legislature, then I think if you read the statute like I've indicated you should, not only does 21178-2 make sense now, but 21178 G makes sense, 21178 I1 makes sense, 21178 I6 makes sense, and 21178 L makes sense. I won't go into the different definitions that counsel pulls out in his brief. Quite frankly, we've supplied alternate definitions that, again, are consistent with the due process notice standard. And even if this court says something more than due process is required, the findings of fact and credibility of the witnesses show that occurred. Constructive notice was found, constructive notice as opposed to simply due process notice, and also that he received at least some of the written notices based on the fact that his testimony wasn't credible and they didn't come back, the mail delivery did not return. So I think that this court has to, one, give some leeway to the circuit or to the court of claims judge who looks at the witnesses and is there and determines whether the witnesses are telling the truth or not.
Thank you, Mr. King. I believe your time is up unless Justice Zara has any follow-up
Well,
questions.
thank you very much.
Thank you. Mr. Lindstrom, you have some rebuttal time. We lost the clock, but I know you had some. And it was 9-ish minutes, I think.
Thank you, Your Honor. I'd like to start with the point about whether there was a finding of actual notice. So first of all, with respect to the mortgage holder, RFA, the Court of Claims expressly relied only on constructive notice. That's page 13A of our appendix. So that means the question of constructive notice was the only basis with respect to the mortgage holder. And even as to the property owner, that's not a finding of actual notice. The finding was merely an adverse credibility determination, which just meant it didn't give any weight to property owners' statements, but that doesn't amount to evidence on the other side of the scale. So, and in fact, there's a number of things of affirmative evidence that strongly suggests he didn't receive actual notice. For one thing, once he was notified after the foreclosure was made, he tried to pay, right? He tried to pay his taxes as soon as he was actually notified about it. And the other evidence that when he's notified about his taxes that he pays them is that he paid them for other properties that he did receive. That cuts in his favor, not against him. And that's in the, I think their appendix at about 219B and later 269, 270B. So when he gets the notices, he's paid it in the past, and he tried to pay it here, and then they sent the check back. They didn't accept the check. So that's not the basis of the Court of Claims decision. It wasn't the basis of the Court of Appeals decision. In fact, amici on his side, the Michigan Association of County Treasurers, says on page 23 of their brief that there was no finding of actual notice. They agree with us on this. So that's why this case is an important case, because it actually does present the question of whether or not actual notice is required by 78L, as this court understood it in Perfecting Church. So I'd like to talk about some of the provisions that he covered, because he said that this is about statutory construction. I firmly agree with that. And the statute doesn't use the word actual, he points out, but the context supplies that. Context answers that, right? The entire point of all the provisions before 78L is to provide at least constructive notice and a high level of constructive notice, because that's what due process requires. It requires notice that's actually intended to apprise the person of the circumstances. As to 78.2, which is another provision he relied on, he still hasn't responded to the point that 78.2 specifically applies only to provisions that are about the return, forfeiture, and foreclosure of the property. That's quoted language from the statute. It also refers again to those provisions. And 78L is not one of those provisions, as we explained in our brief. You know, you can't get the property back. There's no return. It doesn't undo the forfeiture or the foreclosure. All you can get is money damages after the foreclosure is done. So 78.2, that part of it definitely doesn't make sense with his interpretation, because that interpretation is the legislature said this in 78.2 and then wrote 78L, but didn't mean it to do anything, right? Because that would say 78L isn't adding anything. And additionally, 78.2 is also about how courts are supposed to construe those earlier provisions. It's not about the express cause of action created in 78L. I also like to address 78A real quickly, because that's again a point where the plain statutory text says the treasurer shall notify. So he points to the preceding sentences, which give a permissive option that if somebody wants to make sure that the government does its job, then they can pay an additional fee to increase the chances that they'll receive the notice that they're otherwise entitled to. But to say 78A doesn't require notice require reading out the shall. It would require, his argument was also require reading out the fact that 78L itself in subparagraph 1 expressly refers to unrecorded interest. The legislature expressly wanted to address unrecorded interest. And then additionally, it would require interpreting 78I-6, which he points to. 78I is expressly limited to that section. It doesn't apply to 78A4. And I haven't heard a response to any of those textual points. And it's also somewhat ironic that they're saying that even though they had the notice from the mortgage holder in their own files for 8 months before the foreclosure, that the mortgage holder is out of luck because they had constructive notice, but the county that had the recorded mortgage in its own files for 8 months, that it's not responsible for knowing that. I can continue to use my time, but if there's more questions, I'd be.
Let's see if anybody has follow-up questions. Justice Viviano, again, I'll start with you.
I do not. Thank you.
Justice Bernstein.
No questions.
Justice Clement.
No questions.
Justice Kavanaugh. Justice Markman.
Thank you.
Justice Zara.
Done. Thank you.
Okay, Mr. Lindstrom, do you want to conclude? I think you still had a couple of minutes left. I'm kind of going off my phone at this point. They're working on the clock issue. It'll be resolved for this afternoon's cases, but.
Yes, Your Honor. I would say that the kind of the big picture is we still haven't heard an explanation from the other side of what 78L is about, what it's trying to do. Again, if I were to lose my home to a foreclosure without receiving due process, without receiving a high level of constructive notice, then I can bring a claim and get my property back without 78L existing. So as this court recognized in Perfecting Church, it's an additional statutory remedy that's for actual notice. And the overall context of the statute, I mean, there are a whole number of provisions that are all about providing constructive notice. So that's the legislature's scheme anticipated that you can only get to this point if you've actually received constructive notice by that point. Excuse me, you've actually received actual notice by that point. And so it really does require, if this court would uphold the Court of Appeals interpretation, it really would mean that 78L would be a dead letter. And neither the amici nor my friend on the other side have provided any counterexamples to show that this court would not be interpreting that statute to be a useless thing if it continues to uphold if it lets the Court of Appeals interpretation stand. So I would ask this court to follow the plain language of the statute, which provides a remedy when you didn't receive any notice, and it covers unrecorded interests as well. Thank you, Your Honor.
Thank you very much, Mr. Lindstrom. If there are no final questions for Mr. Lindstrom, I'll hold for a second. Okay, seeing none, the case will be submitted. And I misspoke earlier. I thought we had 4 cases this morning, but that's incorrect. We will take a break now and return at 1 o'clock for 3 additional cases. Thank you all very much.